Today was closing arguments in Karen Read's retrial. The jury has got the case, and they took the weekend off after a couple hours of deliberating, and they're going to continue deliberating Monday morning. So maybe we will even have a verdict by Monday. Now, I think it's worthwhile to go through the closing arguments because Alan Jackson's closing argument was just phenomenal. It was hands down amazing. There's so many good parts about it, and I want to play for you some of the clips, some of the highlights from his closing argument. It's definitely worthwhile to sit down and watch the entire closing argument of Alan Jackson in one sitting. It's just it's a long time. It's about an hour and a half long, but it's really very, very well done. It was organized, and he just made so many great points with his closing argument, so many great arguments that he made. So let's go through some of the closing arguments. I'm going to play you some of the clips, and we will see, and I'll show you why I think a lot of the parts were really, really good. So first, he started off with the same theme. Now, remember the theme that he started off with in opening statements? There was no collision. There was no collision. He came back to that theme. That's also very good. Really good. When you come back to the same theme that you set out in the opening statement, it kind of reminds the jury, see, we told you about this, and now we proved it. There was no collision in this case. Now, he also spoke a lot about reasonable doubt, which is great. Something that also I think was lacking in the first trial is that he didn't really stress enough and explain reasonable doubt. And here he really did a good job explaining reasonable doubt to a moral certainty. She's presumed innocent. It's the highest bar the law provides. Even if you think she's probably guilty or very likely that she's guilty, still your verdict has to be not guilty. So he stressed this. He explained it. He explained how such a burden, such a tremendous burden of beyond a reasonable doubt is in order to overcome, in order to find somebody guilty in America. So great job stressing that standard. And then he started talking about the night. So he said that night they were in good spirits. That night everybody knew that they were in good spirits. And the Alberts, they met them at the waterfall, and the Alberts they're a very influential family. They have quite the reputation. And also he pointed out, this is just the first example of it, but he kept pointing out what the Commonwealth did not do in this case, which witnesses they did not call in this case. And again, showing the jury that they don't have the full picture. So he says right away, Matt McCabe, who you did not meet in this trial. They did not call Matt McCabe. And then you also didn't meet Brian Higgins, who had romantic designs for Karen Read. And he spoke about the text that Brian Higgins, after being ghosted for a week, finally sends to Karen Read while she is there with her boyfriend, John O'Keefe. And then he showed the video of John O'Keefe and Karen kissing right in front of Brian Higgins after him being ghosted for a week. And then right after that, he plays the video of what happened after that was Brian Higgins sparring with Brian Albert. Then you see the next part of the video where you have Chris Albert grabbing Brian Higgins' hands down, and you see that there's something going on there, which I think the jury should be thinking about. What exactly was going on in that little circle there with Brian Albert, Brian Higgins, and Chris Albert when they're about to leave the bar, and Brian Higgins is trying to motion to John O'Keefe to come follow them, and he showed that, and obviously it was the motion of come outside, come join us outside. All right, well, all of this, of course, Michael Proctor ignored. Now he spoke about the obvious dog bites to John O'Keefe's wounds, so he kept referring to them as dog bites because that's what the evidence showed in this case, that they were dog bites. And then he also reminded them that at 12:36 a.m. is when Karen Read's phone connected to the Wi-Fi in John O'Keefe's home, and that's obviously very important in the case. Then he did something which is also really great, is when you use the other attorney's arguments against their own position. So this is a quote that he talked about when Karen Read got to 34 Fairview the next day. What was going on? What type of chaos was that? So listen to what he says here.
At 6 a.m. when Karen found John, you heard about the scene. It was described in detail. It was chaos. To use Mr. Brennan's word in his opening statement, it was bedlam.
To use Mr. Brennan's statements, when you use the other attorney's statements against them in their case, that is just gold. And that's what he does consistently without his closing arguments. He's using things that the Commonwealth has presented and arguments that Brennan made. So even Brennan agreed that there was bedlam at the scene.
The screams for help by Karen, the yelling and the hollering, ambulances, emergency lights, fire engines, ladder trucks, paramedics, patrol vehicles, patrol officers, all of them swarming all over the lawn, just under Brian Albert's bedroom window. And of course, as you learned during the course of this trial, Brian Albert, a sworn peace officer, a first responder trained in being a first responder, never came out of the house. Never went outside to help a fallen fellow officer. who was laying on his own property. Never came out. And you learn through the undisputed evidence that the lead investigator, Michael Proctor, for his part, never went into the house.
What a great parallel there to show Brian Albert never came out of the house. Michael Proctor never went in the house. It's just like it's poetry. It just works so well, and it makes your point so strong.
The Commonwealth has struggled to try to prove that John O'Keefe ended up in Brian Albert's front lawn because he was struck by a vehicle. They have failed. They cannot and they will not ever be able to prove that John was struck by a vehicle beyond a reasonable doubt and to a moral certainty, because the science does not lie, the medical evidence does not lie, the physics do not lie. Their investigation was flawed from the start because their investigator was corrupted from the start by bias, personal loyalties.
And that is, of course, Michael Proctor. So then he goes on talking about the fact that there was no impact site, according to Dr. Scorti-Bello, who was the medical examiner in this case and was not able to come to a determination about whether this was a homicide or not. She left it as undetermined. And she said that she couldn't tell whether this was a car accident because she could not see any evidence of an impact site. Okay. Then moving on, he said that the Dr. Scorti-Bello was actually presented with the Commonwealth's theory, but still refused to buy it because she did not see evidence on his body of that. And then he started talking about Dr. Rentschler and Dr. Wolf and their accident reconstruction, as opposed to the accident reconstruction that was done by Dr. Welcher. We will all, of course, remember Dr. Welcher's reconstruction, but just listen how he frames it, because he just does such a great job in framing the difference and making his points and his arguments.
Dr. Dan Wolf did the testing on the taillight, actual testing, not some ridiculous blue paint kindergarten project. He didn't
see the way that he framed that. It's like something that you can really be thinking yourself. And he just comes out and says like that. He argues, obviously this is his closing argument. And if he frames like it looks like a kindergarten test, that's literally what it looks like. When you compare it to the ARCA experts' actual reconstruction, what Dr. Welcher was doing was laughable. It's child play.
Lab testing. He did field testing. He did data testing, actual impact force analyses. In every single test at every single speed, the taillight damage was inconsistent with striking an arm. In every test, the taillight damage was inconsistent with damaging the shirt, the sweatshirt.
Right, two parts. It's inconsistent with the taillight. It's also inconsistent with the John O'Keefe's sweatshirt. In every single one of the tests that ARCA did, not the kindergarten paint test.
Remember that severe internal damage to Karen Read's taillight. Not just the outer lens. The internal diffusers were completely smashed, completely shattered. ARCA testing established that all the internal components of every single test taillight, especially the diffusers, remained completely intact. Conversely, on Karen's taillight, the diffusers were almost completely gone. Folks, understand something. If any part of that diffuser portion of the taillight is broken, there is no light. It doesn't illuminate at all. It's just black. Let's take a look at a couple of photos.
So remember that internal diffuser, the fact that it's fractured and broken and completely destroyed in Karen Read's Lexus, and in the testing, it was not that. It was maybe a little bit of cracked, a little crack, but it wasn't destroyed. And remember, if it's destroyed, then you don't see any light. And look what he does here for the jury to show when exactly did Karen Read's Lexus not be able to light up in the back? When were those internal diffusers really destroyed? Well, look at the timeline here.
At 5:07 a.m. at One Meadows, that's the photograph on the left. What do you notice about the right taillight? It's completely illuminated. Later, at 4:12 in the afternoon, photograph on the right, it's lit up. How can that be? How can that be if the Commonwealth claims that those diffusers, the portion that lights up the light, were already scattered all over 34 Fairview? That's their theory. But don't believe your lying eyes. The taillight's completely lit up. That would be impossible.
Only one answer, right? Michael Proctor. Somebody did something to that taillight.
Dr. Andrew Rentschler, a PhD, a biomechanist, explained that at those speeds, the other side of that coin, John's arm would be basically destroyed. Contusions, swelling, torn ligaments, hyperextensions, dislocation of joints and bones, fractured, broken, and shattered. But as you know, John's arm was pristine, save those dog and claw bites. He didn't even have a bruise. Think about this.
See the way he just refers to them as dog bites. He doesn't say the injuries to John O'Keefe's arm, which we are arguing is a dog bite. He just says those dog bites on his arm.
Think about that photo of those x-rays as you deliberate. You can manipulate a taillight fragment. That's not that hard. You can't manipulate a bruise. If they claim the car was going fast enough to shatter the taillight and shatter the diffusers, then it was also going fast enough to destroy and shatter John's arm, and it simply did not. How do they square that? They don't, and they can't. So they spent nearly $400,000 of taxpayer money to hire someone to dress up and look like John and paint his arm blue.
You see how, again, the framing is just beautiful. So they spent $400,000 of taxpayer dollars to dress up in John's clothing and paint his arm blue.
Which told you exactly nothing. The ARCA testing, conversely, also established that it is impossible for John's sweatshirt sleeve to be damaged by an impact with the taillight. The Commonwealth's theory is that the sleeve of John's hoodie sweatshirt was damaged by flying shards of taillight slicing through the shirt and through John's arm. I have 3 questions. Number 1.
Now, this is great when he says, I have 3 questions, because you know what Hank Brennan could do now? This is what essentially Alan Jackson is setting up. He's setting up, look, these are my 3 questions. And what he could have done, just to like really hammer this point home, is that he could have said, I hope Hank Brennan will get up here and answer these questions. Because guess what Hank Brennan did with these questions? He didn't answer them. He did not answer them at all. But he could have just made this point. And here, he's asking the jury, here, these are these 3 questions. Let's see if they'll get up here and answer these questions.
John's arm had about 36 abrasions. How did 36 shards of acrylic go through 9 tiny little puncture holes? How'd that happen? Somebody needs to answer that. Number 2, why are there no slices or cuts in the hoodie? All the defects are punctures. Punctures that you might get from, say, I don't know, canine teeth. And number 3, if the shards cut bloody gouges into John's arm, that's their theory. Why is there no blood, no skin, no tissue on a single shard of taillight that they claim came in contact with John's arm?
No, pretty strong question there. If it came into contact with John's arm, and you would think that there'd be some blood there, some tissue, some something, and yet that there's going to be no DNA. He's going to come back to this point a little bit later. So then he goes on to say the difference between Dr. Welcher and the ARCA, and the fact that Dr. Welcher leaned in on that test in order to manipulate the test. And then he, again, uses Dr. Welcher's own words to bring home his point. And again, when you always able to use the other side's witnesses to bring home your point, it's always going to ring very loud for the jury.
Compare and contrast the ARCA experts and their actual testing to Judd Welcher. He came to you in the Commonwealth's case in chief, and he told you that for the better part of $500,000, he'd come in and testify that John was tall enough to touch the taillight with his elbow. That's it. And even in that basic demonstration, he had to lean in to manipulate it to get the results that he wanted. Dr. Welcher then claimed that the reason he didn't do the reconstruction, the actual testing, think about what he said. There isn't enough evidence to determine what happened. I beg your pardon? What happens when there isn't enough evidence, in his words? You vote not guilty. That's what happens.
Exactly. That's exactly the point. If you cannot tell the jury what happened and you are the Commonwealth, well, then guess what? That means that there is a reasonable doubt at the very least, but that means that your vote has to be not guilty. Okay, then moving on, he says about how Dr. Welcher, according to Dr. Welcher's data and his report, that the interaction had to happen 11:62 was at 12:31 and 38 seconds, and that was a real problem for the Commonwealth. So what are they going to do with this problem of Dr. Welcher's timeline not adding up with how the case is, how their theory of the case is? So listen to how, again, this is framed for the jury by Alan Jackson.
Remember, the collision immediately incapacitating. How could he be interacting with his phone afterward? He was on his phone, opening his phone, checking his phone, reading texts on his phone, and locking his phone, all of it after 12:31:38, which is the time Welcher clocked for the moment of the impact. And he was taking steps and walking with that phone after 12:31:38 also. That's what their own data showed, and it devastated their case, and it devastated that false theory. There must have been panic, I'm guessing, in the room. What do we do now? The data shows John wasn't struck by the car. What do we do?
So you see the story that he's saying, he's creating this story really, but he's saying it in a story. And this can really resonate when you're saying these facts as a story, even though he's embellishing, obviously, and he's creating facts, but this is part of argument. This is exactly what you're supposed to be doing in closing argument. So they had to figure out what to do in this case. So they went back to the drawing board. And you can kind of envision this on the jury. You have this could have happened in the middle of a trial, and you're painting this whole picture. And then it's just hard for you to imagine that that's not what happened.
Enter Shannon Burgess. Question. Can you believe him? Can you believe Mr. Burgess? He came up with a brand new story right in the middle of trial. You might ask yourself, would an expert actually say something he knows not to be true? Would an expert actually say something he knows is not supported by fact? Would an expert shade the truth? You don't have to look any further than Shannon Burgess's CV to answer that question. That was a shame.
Right. And that was a shame. And that's why he's completely not credible in this case. So he comes in the middle of the case. He is guilty of one of the cardinal sins of being an expert, confirmation bias, and he tries to change the timeline to fit with the Commonwealth's theory. And this is a person. Well, would he stretch the truth at all? Would this type of person stretch the truth? Well, just look at his CV. Look at all that debacle, what happened there. So yeah, this is a person that would start changing things around. So that was where he spoke about there. And then he spoke about the phone battery and the difference in how fast it was getting colder, the phone battery, and also the fact that it was moving in a westerly direction towards the house, and it only took 78 feet to get there to the garage door. Okay, then moving on to the arm. So he's talking about the damage to the injuries to John O'Keefe's arm. And let's pull that up. Take a listen.
Get hit by a car. The Commonwealth has not met their burden. They cannot meet their burden. The Commonwealth hasn't called a single medical professional, not one, to testify that John's wounds came from being hit by a car. Not Dr. Scortibello, not Dr. Isaac Wolf.
Not one expert from the Commonwealth said that those injuries to John O'Keefe's arm are consistent with being hit by a car. And the defense has called experts who said that they are consistent with being bitten by a dog. A bunch. And the Commonwealth, zero.
Contrast that with the caliber and the quality of the experts who came in here to tell you what is obvious to anyone with common sense. Those wounds on his right arm are from a dog. This was not an oversight by the Commonwealth. It's just that there is no one out there. No matter how big a check you write, there's not a medical expert who's going to disagree with that.
And again, bringing back the $400,000, which of course the jury is in the jury's mind about how much they're willing to pay. And no matter how big of a check, you have a blank check on behalf of the Commonwealth. You're spending $500,000 for people to dress up like John O'Keefe and do a paint test, kindergarten paint test. And you can't find any expert to say that these wounds are from the car. These wounds to John O'Keefe's arms are from the car, no matter how big of a check you write. Just can't do it. So then he starts talking about he goes into the house, the fact that they didn't secure 34 Fairview. There's no photos of the house. There's no search warrants. And you had Lieutenant Gallagher saying that he didn't know that there was a crime committed. When you think about the situation in which Lieutenant Gallagher was presented with, right? Not what we know now, but what he was presented with. The fact that there was a broken glass, so he was missing a shoe, he was not dressed for the weather, he had black eyes, he had a bloody nose, all of that. The fact that he was invited even into the house. I don't know why Alan Jackson didn't say that part, but he could have. The fact that he was invited to this house. And that's what Lieutenant Gallagher was presented with, and there's no reason to search the house at all, even to attempt to. And then the fact that the neighbor, Kelleher, the deputy Kelleher, he had a ring camera that was pointed in the same direction of John O'Keefe where John O'Keefe was lying, where it would have caught everything, but no one even bothered to look at it or to secure it. And then he started talking about the text messages that Michael Proctor wrote. Nope. He's meaning the question about whether the homeowner is going to catch any grief. He said, nope, he's a Boston cop too. And that was in a private chat just hours after John O'Keefe was located. And he says the exact exhibit number for the jury. Now, this is just one thing about this case that I something I disagree with. But again, I disagree with a lot of things that Judge Cannoni was doing in this case. And that is that she does not allow the jury to take notes during opening and closing statements. Why? Because it's not evidence. You're right. It's not evidence. But maybe I may, as an attorney, make a reference to evidence that may put in the mind of a jury, okay, I want to go look at that piece of evidence. So make a little note. Oh, make sure to check out Exhibit 209 in this case, which were the text messages. But she doesn't allow any note taking during opening and closing statements. Opening statements or closing arguments, which again, I don't agree with. I understand it's not evidence, but still it can help you and think about the evidence. And maybe you want to make some notes. Maybe a thought will come into your mind that you'll lose by the time closing arguments are done. So it doesn't make sense to me. I understand there are certain trials where they don't allow any note taking. Okay, fine. So you don't want to allow any note taking, then okay. Once you're allowing note taking, why not allow note? What's the damage? What's it going to hurt to allow the jury to take notes during opening and closing statements? You already told the jury in a number of instructions that the attorney's statements are not evidence. Fine. But they may be talking about the evidence, which may cause you to want to look at a certain evidence. And maybe you want to make a note about that. So again, so he goes through more of Michael Proctor's text, and he says, 0 chance she skates. Now, this is Michael Proctor talking a couple hours after he got involved in this investigation, saying there's 0 chance. This is his full investigation. He's done. He's done with the investigation a couple hours after John O'Keefe's body is located, after they have their fall person, Karen Read. He's done. 0 chance she's skating. And then she says she's effed, a bad word. So, and again, with a lot of the other bad texts that he was sending that day. And then you have his superior, his supervisor, Buchanan, who likes the text. He likes that by the no nudes yet, which he claims is just acknowledging. Okay, so then let's get to the next clip that I want to show you. And again, another great way to frame this issue.
Fact finder, no bias, no agenda. Michael Proctor went far beyond just insulting Karen Read. He dehumanized this woman. He betrayed her as a human being. He was fired for this blatant bias. If the Massachusetts State Police can't trust him, how can you trust him with this investigation and with your verdict?
Right? What a great way to frame it. If the Massachusetts State Police cannot trust this person and gets rid of him, you're going to trust his investigation that he led in order to lock this innocent woman up right now? Again, she's presumed innocent. Of course you can't do that.
And with Karen Read's life. The lead investigator in a murder trial was never called to testify. Think about that. That should stop you in your tracks. Wouldn't you want to hear from Michael Proctor? Wouldn't you want to hear from the lead investigator in the case? Don't you have questions? The Commonwealth did not present their own lead investigator to the jury, the very jury who is charged with judging the investigation. Michael Proctor clearly is radioactive, and the Commonwealth stayed away from him. Michael Proctor is no longer a Massachusetts State Police officer. He wasn't transferred. He didn't go on sabbatical. He didn't retire. He didn't resign. He was fired. He was terminated for cause. The Massachusetts State Police investigated him, found him guilty of dishonorable conduct, not just for those text messages, folks, for sharing confidential information with witnesses and for bias. Not just any bias. Bias in this case. Fired.
Which is, again, is very significant. It's not just that he was fired for bias. You have a biased police officer. No, it's the bias that he exhibited. In this case, he was biased. You saw that yourselves from the text messages. And you're going to go take this biased lead investigator's investigation and use it to lock up Karen Read? That's what you're going to do? So again, this is just great, great stuff from Alan Jackson. Okay, then moving on a little bit further to where he's talking about the DNA or the lack of the DNA on the taillight. Just get there. 1 second. Here we go.
Now let's talk about some of the other problems with the Commonwealth's evidence. As I indicated, there was no blood, no skin, no tissue, no DNA found on a single piece or shard of the taillight that the Commonwealth claims cut and sliced into John O'Keefe's arm. Where is that trace evidence? Where is that biological evidence? The DNA. Where is it? I got nothing. Not a single piece that the Commonwealth wants you to believe cut up John's arm. How is that possible? It's not possible. The only way it's possible is if those shards never touched his arm. Because it was a dog.
Because it was a dog. Exactly. That's why they have no DNA on the taillight, on those shards of taillight. Because it was a dog. And again, it's a little bit dramatic. You know, you whisper to the jury, but that's the secret of the case. That's exactly what the secret of the case is. That's why you do that gesture. This is something the Commonwealth is trying to hide from you, but this is the secret of the case. It was a dog. So yeah, it's a little bit of theater, but that's what you need to do in closing arguments. You would just make your point so much stronger.
Oh, and the one sample of DNA that they did find, by the way, was found on the outer smooth part of the housing, not any shard. It was the outer smooth part of the housing. Nothing that they claim actually came in contact with John O'Keefe. Number two, that sample had DNA of two other men, two other unidentified males. That tells you that that DNA had nothing to do with a car strike. That DNA would be expected to be, John's DNA would be expected to be all over that car, inside, outside. He had access to that car for months and months and months. He was in and out of it all the time. Show me some blood, then we'll talk. They can't, and they won't because it doesn't exist. That SUV never hit John. The hair found on the bumper. The Commonwealth really stretched its own credibility on this one. That magic little hair on the SUV supposedly survived a 37-mile drive in 47-mile-an-hour winds.
The magic hair, and this is kind of how I framed it after last trial, calling it the magic hair. Maybe that's where Alan Jackson got it from. But yeah, this is the magic hair. This is the hair that somehow on the smooth surface, the outer part of the housing, the smooth surface, it somehow drove 37 miles in a 47-mile-an-hour windstorm or blizzard, and somehow that hair is still stuck there. Okay. Then moving on a little bit more. Let's get to this part.
Commonwealth is embarrassingly grasping at straws. That hair has nothing to do with anything. But it doesn't stop there. There was another revelation at trial, a big one, a huge one, and it came from a very unlikely source. Christina Hanley, a quiet, reserved criminalist who told you something the Commonwealth likely did not want revealed because it's devastating to their case. Absolutely devastating. And it's this. The glass on the bumper didn't match the cocktail glass. None of it.
None of it matched the cocktail glass. The glass was found on the butter, just on the bumper. It didn't match the cocktail glass. So where in the world did it get? Where did it come from? Where did that piece of glass come from that ended up on the bumper? That's the question in this case. And you know what? This is what Alan Jackson explains, that there's also happens to be some other, it does match some other glass that was found in front of 34 Fairview by an individual named Michael Proctor. So that's what it was. All right. Then moving on, he spoke about Lucky Loughran and the fact that he saw Ford Edge there at 3:30 in the morning, parked in front of the lawn, exactly where John O'Keefe's body was located later. And of course, he was never interviewed by Michael Proctor, because what can Lucky Loughran possibly add to this investigation when you decided from day one that the girl has zero chance that she's skating? Then you have also Michael Proctor waiting years to interview Ryan Nagel and Heather Maxim, and both people who only saw Karen Read in the Lexus and did not see John O'Keefe in the Lexus. Where could he have been? Where could he have been, right? Also, the fact that Lucky Loughran did not see anybody in the lawn. Okay, that was also significant. Not just that he saw the Ford Edge. And, okay, then he also spoke about trying to make the argument that Karen Read was not really drunk that night, and they don't really, he messed up. Buchanan messed up how many drinks she had. But this really gets to the fact that this time the Commonwealth actually added in the lesser included just plain OWI, just plain driving while under the influence. That's it. So if the jury finds that she was above the legal limit, they could find her guilty of drunk driving. And that's what I said, by the way, in the last case. I think I said that the best chance after the first trial, the best chance the Commonwealth has for a guilty verdict is if they would have just charged her with OWI or DUI, whatever they call it in Massachusetts. That's what they could have charged, and they would have had the best chance of getting a guilty verdict. So maybe that's why they're taking my advice also and actually added that to the verdict form this time to be able to charge her with just OUI. But I will say that I think it would be interesting if a jury would acquit her of everything on that verdict form except just plain OUI, because they would probably be disgusted. The fact that someone's dragged in, sat through all this trial, was put on trial for their life, essentially, second-degree murder, which carries a life sentence, possibly. And they're just going to walk out of that jury room and convict her of just plain OUI. So I'm not sure about that move either, although I think that this is their best case. The Commonwealth's best case would be to get a conviction on the OWI. But still, Alan Jackson made some arguments about that. Okay, then moving on to the next part of the closing argument.
Investigators never opened that door. Let's change the scenario. What if it wasn't the house of a Boston cop? What if it wasn't the house of Brian Albert? We can be certain that investigators would have torn that house apart to get answers about why a fellow police officer was laying dead on the homeowner's lawn. You can betcha. But because this was Brian Albert's house, a Boston cop, nope. And because he was a fellow cop, an insider, they didn't even open the door. That is not justice, folks. That's just pure favoritism.
And that is also just such a great point. It's a point that I've been making all along. The fact that his house was not searched was only because of one reason. It's very, very clear. And I think every single person on the jury understands this. The reason that house was not searched was because it was owned by a Boston cop. Period. End of story. That's it. Full stop. If it's any other person who's not a Boston cop, that house is going to be searched. It's going to be torn up. Exactly how Alan Jackson framed it. And I think that's very clear to the jury, and I think they kind of believe that. Okay. Then he spoke about Jennifer McCabe's phone records, about the fact that she had a 38-second phone call at 5:07 a.m. that morning, right before they discovered John O'Keefe's body, and she also conveniently lied about that. So Jennifer McCabe lied about that 5:07 phone call that she was calling over to her sister, Nicole. Okay. Then Michael Proctor didn't secure Brian Albert's phones, didn't even ask about it. Also, the dog, Chloe, who's not good with strangers, disappeared and then got rid of altogether, rehomed. And we have Dr. Russell saying that it's consistent with the dog. Right, so he spoke about that. He also spoke about the group chat where Matt McCabe, again, who was not called and you did not hear from, that he said, tell him to say the guy never came in the house. And Brian Albert says, exactly. This is people coordinating what they should be telling the cops. Or that's what it looks like. Or what their story should be. Then he spoke about the Google search, Jennifer McCabe's Google search, house locked and die in the cold, and the fact that the search was deleted, and that she enlisted Carrie Roberts to help shift the blame to Karen Read. He spoke about Karen Roberts' admission of perjury, that she said that she heard Jennifer McCabe tell Karen Read tell Jennifer McCabe to Google house locked to die in the cold, and really she had to take that back in this trial, that she really did not hear Jennifer McCabe say that. Then we also have Jennifer McCabe saying, listening into Carrie Roberts and saying in her group text, she's telling them everything. So again, you have people that are listening to other witnesses being interviewed and sharing information, which again, looks like they're colluding together. Then he got onto the fact that Karen Read said at the scene, I hit him. And the fact that obviously does not appear in any sort of report at all. And even in Jennifer McCabe's grand jury testimony, doesn't say anything about that either. And they're all just questions. They were not statements or affirmative statements that Karen Read actually said that I hit him, although he did kind of weave in the fact that Dr. Russell, I think also Dr. LaPosada also said that people in grieving situations, that is a grieving reaction. You try to figure out whether you are at fault and that you had anything to do with this close relative's death, especially if you're the last person with them. Then we have Jennifer McCabe calls her sister when she arrives at the scene at 34 Fairview that morning with Karen Read at 6:07, no answer, calls again at 6:08 a.m. While Karen Read and Carrie Roberts are trying to work on John O'Keefe and try to save him, Jennifer McCabe is busy calling her sister. She doesn't go into the house to check on her family to see if maybe something's wrong in the house. You have this person dying and dead who was at the house, who's at that house of your sister, and you don't think that there's any reason to check on your sister in the house. Okay, then let's move on to where he's talking about what Buchanan. Now remember, there's a lot of material that he could have used in Buchanan because Buchanan refused to answer any questions. So he could have used a lot of information, but this is the line that he chose to single out to the jury.
And don't you have questions also about Brian Higgins? Michael Proctor certainly didn't. Higgins had been sending flirtatious and romantic texts to John's girlfriend, Karen Read. You'll remember I asked Sergeant Buchanan a simple question. Were those texts flirtatious in nature? He refused to answer that simple question. Do you remember that? Quote, I'm not comfortable putting a label on that, end quote. We read the texts. It's not a secret. Of course they were flirtatious. Of course they were romantic in nature. The reason he refused to answer that simple question is telling. It's because these flirtatious texts established a motive for Brian Higgins. Sergeant Buchanan could not bring himself to tell the truth. His bias was on full display. He was covering for another cop. Investigators also ignored Higgins' suspicious late-night visit to the Canton Police Department. That was after a night of drinking, by the way. Why didn't they investigate this? What was so important that Higgins needed to go to the police station at that time, 1:30 in the morning, while drunk, by the way? Why weren't they interested in those facts? Remember, he's an ATF agent. He's a cop, a member of the Blue Wall, and best friends with Brian Albert. He would know that the CPD would be the first to get the call when someone reported John missing or injured. He would know what to look for, what to listen for, to determine if a report had been made and when and what the response was going to be. You saw the skulking through the hallways with his hood up, moving bags between cars, and of course, that late night mysterious phone call on his cell phone, a phone that you don't have and that you'll never see.
And you also never hear from Brian Higgins because the Commonwealth refused to call him and present him to you in this case. So that was that part. And then he got on to Kelly Dever. I remember Kelly Dever and the 42 minutes of the Sallyport video, which vanished, which she initially told the FBI agents, which we know are the FBI agents, that she has a pretty clear memory about it. And then all of a sudden she had a false memory. So listen to how, again, Alan Jackson is framing this issue for the jury about Kelly Dever. He does a great job.
It's revealing what happened here at trial. One of the most dramatic moments probably of the trial, Kelly Dever. How can you trust this investigation when you saw how far a police officer will go? You had a front row seat to the power of police manipulation and police corruption, a front row seat. Kelly Dever was interviewed by a separate law enforcement agency, not a friendly department, not Boston Police Department, not Michael Proctor's MSP, a different independent agency. She told those law enforcement agents in a formal interview that she saw Brian Higgins and Chief Kenneth Berkowitz alone in the Sallyport with the SUV. She was detailed, she was clear, she was unequivocal, she remembered the specifics, she recalled how it made her feel, quote, weird. She recalled that how long Higgins spent, a quote, wildly long time, as she described. These are all incredible details to tell law enforcement. She couldn't have been clearer, she couldn't have been more specific. But then she's put on a witness list and she's subpoenaed by the defense. Oh boy. Then this rookie cop was called up to the police commissioner's office, the same commissioner that was the boss of Brian Albert. They have a meeting, a private meeting, and he says, wink, wink, nod, nod, we support you, Officer Dever. What else was said in that meeting? What else is reasonable to believe was said in that meeting? She claimed she couldn't remember. She claimed not to remember if he instructed her to do the right thing. But the commissioner of the Boston Police Department certainly said something to this rookie cop. And all of a sudden, that detailed, unambiguous, unequivocal statement to law enforcement became, what did she say? A false memory. Not I didn't say it. She admitted she said it. She admitted she detailed the entire story. She just said, it's a false memory. What? So she's called to the commissioner's office to make sure that she would do the right thing. That's why she was called. And now we know what that means. In her words, my entire career depends on what I say here on the stand. I'll quote that again. Quote, my entire career depends on what I say here on the stand. You bet it does. That's how it works. And that's how we got here.
So you see just the storytelling ability. He takes Kelly Dever's testimony, which he could have made a few points about it. He could have done what Hank Brennan kind of did in his closing argument. You know, you attack this, you attack that, you explain this away, you explain that away. But when you say it as a story, and that's what he did, he just creates a timeline. He says it as a story. Storytelling is so important when you are closing a case, when you're opening a case, also when you're talking to anybody. People like to listen to stories. They like to be engaged with stories, and especially things start to make sense in your mind when you present it as a story. So he presents this whole story of Kelly Dever, how she has this vivid memory with specific detail on how it even made her feel. All these specifics, nobody injected that into her head. Like sometimes you have false memories and someone injects a false part of that memory into your head. That's not what happened. She remembered everything specifically and sent it over to the independent law enforcement agency, the FBI. And then all of a sudden she gets subpoenaed, and then all of a sudden it's a false memory. What? What are you talking about? You know, it's one thing if there's a portion of that was injected and introduced by somebody with such a false memory. The entire memory is false? The entire memory? Not one part of it was a complete fantasy, that entire memory from beginning to end? and how you felt? Were you dreaming? What was that? And this is what you told the FBI. You didn't say, well, I'm not sure if I actually fell asleep at my desk or not. I'm like, that's what you told them as the truth. So, of course, when it's presented like this, the jury can really have some serious doubts about whether Kelly Deborah was being honest. Okay. So now he gets into some Welcher testing, as we saw, the way that he leans into the Lexus again. And then here's another part where he just destroys Welcher. In case there's anything left with Welcher, he just destroys him right here.
Because there was no collision. Dr. Welcher also told you under oath that there were no x-rays taken of John's arm. He tried to deceive you into believing that John's arm might have been broken. I don't know. I didn't see any x-rays, so I can't tell you what the damage was inside the arm. Really? The Commonwealth has had those x-rays in their possession for 3 years. And again, it took the defense to bring out the truth. The x-rays do not fit the Commonwealth's theory, so you weren't shown. And Dr. Welcher wasn't going to admit it. And my goodness.
And that's the question. The question is, did Dr. Welcher actually see these x-rays? And I think he could have also said this to the jury. Did Dr. Welcher actually see these x-rays? Did he really believe that these x-rays didn't exist because the Commonwealth hid them from him because they knew it would be so damaging to their case? Or alternatively, were these provided to Dr. Welcher and he pretended that he didn't see them? Which option is more acceptable to you, to the jury? Both of them stink. So which one was it? Did Hank Brennan and the Commonwealth refuse to turn these over to Dr. Welcher because they knew how damaging it was? And I've had this, by the way. Sometimes you're able to show certain records that are not given over to an expert. And there's reasons for that. And if you can find that record, and I've done this, you can find that record and show it to the jury. They didn't show this record to the expert. You know why? Because if the expert would have seen this record, it would have completely changed his opinion. And they hid it from him. That's option number one. Option number two is that Welcher himself, the expert himself, is being willfully ignorant and pretending that these x-rays don't exist because they hurt his position. Either one is not a great option. So I think he could have stressed that, but he did a great job.
When we get to the sweatshirt, that was a moment. Mr. Brennan stood here in front of you and dramatically held up John's sweatshirt, not just to the witness, but to you, and asked Dr. Wolf about it multiple times. Specifically, while it was in that plexiglass, asked Dr. Wolf about the multiple holes in the back of the sweatshirt. He interrupted Dr. Wolf, and Dr. Wolf started to look at the sweatshirt and say, and he said, how about here? Here's a hole, here's a hole, here's a hole, here's a hole, dramatically tapping on that plexiglass. It was clear what the suggestion was, that the holes in the back of John's sweatshirt were from January 29th. That's the impression that was expected to be left with you. That's the impression that he wanted to leave with you. And that's false. The truth is, the Commonwealth created those holes. They aren't holes from road rash. They weren't made on January 29th. Those are cuttings from the Commonwealth's own crime lab, folks. That's what those holes are. And even with 3 prosecutors, all 3 of them, sitting right there in the room at the time, it had to be the defense to correct that record, to bring out the truth. If we hadn't done that, what impression would you folks have been left with?
And it kind of fits with the whole narrative, doesn't it? The entire Commonwealth, everyone here is trying to pull a fast one on you. They're trying to play these games, and we have to keep them honest. And you're going to use their evidence and their theory of their case to lock this girl up? Is that what you're really going to do? After they try to pull all these shenanigans with you?
That's more than negligence. That's dangerous. It's dangerous. I'm going to guess that Mr. Brennan's not going to say much about this, about the fraud that was attempted on you. And if he doesn't, that speaks louder than any concocted excuse that the Commonwealth might come up with. It's shameful. It's shameful. We are after the truth in this courtroom. You're entitled to it. Demand it.
So again, here he is, and he's challenging Hank Brennan. Get up here, take responsibility, talk to the jury, explain to them why you did that, what you did, and come clean. And if he doesn't do that, he tells the jury this. If you don't do that, if Hank Brennan doesn't get up here and apologize, whatever it is, if he doesn't address it, then that's worse. Right? So he's kind of challenging Hank Brennan, saying, hey, get up here and explain it. And let me tell you something, okay? I understand that there are certain times where if you have another lawyer who's baiting you into doing something, you ignore it. I understand that. But when it's something that's so important like this, your credibility as a lawyer is everything. If the jury thinks they can't trust you, then you may as well not open your mouth and say anything, because they're just not going to believe anything you say. You can have the greatest evidence in the world, but if you're getting up there and presenting it to the jury and they know that you are not a credible person, then they're going to reject it. So yes, I understand the baiting. Sometimes lawyers bait each other to do stuff, but when it is something like this, where your entire integrity is on the line, when your credibility is on the line, if you're Hank Brennan, you have to get up. You have to address it. You just do. And I know you want to be like, oh, I'm not going to get baited into this. No, in this situation, sorry. If you dropped the ball, you made a mistake, you presented something to the jury, which was incorrect, which was false, and Alan Jackson just reamed you out in front of this jury, and you're just going to ignore it, you've lost the case, because you've lost all credibility with the jury. And Hank Brennan did not respond to this. From what I remember, he didn't respond to this. So if you think he responded to this in some way, let me know in the comments. I don't remember him responding to this at all. And I think that if I was Hank Brennan in that situation and I made a mistake, and something you have to do when you're a lawyer, sometimes we make mistakes. Believe it or not, we're not always perfect. And sometimes we forget about it. I think what I would have done if I was Hank Brennan, I would have got up there and I said, ladies and gentlemen, okay, maybe I would have made some other points first, but I said, this case is a complex case. It is. I've been working night and day on this case for the past 6 months. And there is a lot of moving parts. There's a lot of experts. There's a lot of witnesses. There was 31 days of trial. There is a lot going on in this case. And I made a mistake. I mixed up a certain part of this evidence. I thought that there was a hole in the back that maybe was associated with the impact of John O'Keefe. I made a mistake. You're right. Sometimes lawyers make mistakes. I'm not perfect. And just get it out there. Just apologize. Say what you did wrong. Now, I understand the beating. I understand that, okay? I understand that very, very well. And I do that sometimes because I want to bait other lawyers into doing things that I don't think is going to be helpful for them. But in this situation, when your credibility is on the line, when it's everything, when you made a whole big to-do about showing this to the jury and it was false, you have to correct it. Whether you get baited into it or not, you have to correct it. And you have to explain to the jury, I made a mistake. Sorry. This is a long, very complex trial. It's hard. It's hard work, trial work. And yes, I made a mistake. Just do it. You'll win back the credibility. And I don't think Hank Brennan did that at all. So again, just great stuff from Alan Jackson. Unfortunately, the video is already at 48 minutes, so we got to cut it off. There's definitely stuff that I want to talk about with Brennan's closing arguments. I'm not sure I'm going to get a time for that before we have a verdict. Who knows? But we are going to have our Sunday show with national trial lawyer, brother counsel Solomon Radner, 10:30 in the morning. We will see you back here Sunday morning to recap the past week in Karen Read's case, talk about the closing arguments again, see what Solomon's view is on some of the closing arguments and the verdict form, of course. And that's going to be it for now. Everybody have a wonderful weekend. We will see you back here Sunday morning, 10:30. If you haven't, please subscribe and like, and we will see you next time.